Hello, I'm Robert, helping you if you're scared of many things, and this is about people who are scared that about Justice Thomas's opinion in the Supreme Court decision to overturn Roe versus Wade. The one that has, first of all, what the decision itself did is it returned decisions about abortion to the American voters. It didn't say that abortion is illegal. It didn't make any opinion about the right to abortion or pro-life or pro-choice. And so people are now worrying because of this decision that it might overturn the previous decisions that gave a right to gay marriage, to contraception, to interracial marriage even. Some people worry about that for some reason. So first I'm going to talk a little bit about the Roe versus Wade, but not just a quick summary as to where the justices came with that. So, and then we talk about what Justice Thomas, he agreed that the abortion decision is only cast out on cases involving abortion and nothing else. So I'll explain why that is. For those of you worried about interracial marriage, then do bear in mind that Justice Thomas himself is in an interracial marriage with his wife. And of course, if he's a good justice, then he would, if the case on to do with interracial marriage came up, he would have to accuse himself probably, because he's too personally involved. But it's really, he didn't even mention that in his opinion. So it seems exceedingly unlikely that that would even come up. And then to explain about Roe versus Wade, just quickly, the Conservative majority, they see it as restricting the power of the Supreme Court. They say that Roe versus Wade is a very special case because it involves decisions about the status of a fetus. So they first of all, about half the US states want Roe versus Wade overturned, and so it is not settled law in that sense. It's always been disputed ever since it was decided. So the question was, do the American people rely on Roe versus Wade? And they had long section about reliance. It's not correct to say it's based on privacy. Their decision was not based on any considerations of privacy. They said that that's just not relevant early on. In this, they agreed with Casey, which is also not based on considerations of privacy. For some reason, even the president seems to think it's to do with privacy. It's not. And lots of news stories incorrectly say that their decision was based on some arguments to do with privacy. It is based on a careful study of reliance, and the special form of reliance in Casey involves the whether a woman relies on abortion in order to be able to have an abortion if contraception doesn't work, and how much that reliance is to do with their intimate relations and their how they think of themselves in society, and how much they rely on the ability to have an abortion if contraception doesn't work as part of that. And then they said that this can't be separated, it's completely entangled with how we think about the status of a fetus. For instance, is a fetus an unborn human being, as some people claim? So what people think about the status of a fetus affects how they understand whether American people rely on abortion, and how the state of the fetus is related to that consideration. And so they said that the Supreme Court doesn't have the authority or the expertise to decide in this particular case, because they consider that this is something for voters and legislators. Because in order to decide this, the Conservative majority say then they would first have to decide what is the status of the fetus, before they can then resolve the arguments that have gone both ways between those who are pro-choice and those who are pro-life about whether or not the American people rely on abortion. And they said they can't resolve this because they don't have the expertise or the authority to resolve that. So that is basically that is why they then said this has to go back to the American people. And 61% of the American people are pro-choice, so it seems likely in the end that this is going to end up with Roe being codified in some form, because it would be very difficult for the Republicans to go on a platform of codifying the opposite of Roe, for sure. And whether or not Biden achieves it with the midterms, sometime in the future, Biden or perhaps a group of Democrats plus some Republicans, because some Republicans are pro-choice, are likely to eventually decide to codify Roe. So the Supreme Court are turning it back to the legislators to decide whether to codify it on the state level and whether to codify it on the countryside level. So so then if we go now and look at this, it's a completely different situation, that Justice Thomas is suggesting challenges to something very different. It's called substantive due process. And he agrees that the Dobbs decision casts no doubt on any cases except those involving abortion. So what is substantive due process? Well, this is based on 4 words in the Supreme Court. Well, 2 words repeated twice. The word due process, which occurs twice in 2 amendments to the US Constitution. And based on those 4 words, justices over the years in the Supreme Court have built up this whole framework called substantive due process, which is the idea that, and they say based on liberty and based on the history of the United States, then you can derive lots of other rights that are not explicit in the Supreme Court, in the Constitution, if they can be shown as being rights that you have as a result of liberty, and that it would infringe on your liberty if you didn't have those rights. And the other way of doing it through substantive due process, the due process methods, the other way is by saying that historically the United States has always, it's just people expect those rights and they always have had them. And those both are substantive due process. And so many decisions over the centuries, over the years, since the amendments, decades I mean anyway, have been based on substantive due process. And Justice Thomas, he is in a 1/8 minority. He is often in a minority of 1 in the Supreme Court. He is the oldest serving of the Supreme Court justices, and he has minority views very often. And nobody else agrees with him on, indeed, the majority decision for Dobbs of overturning Roe versus Wade used the reasoning of substantive due process. It looked as to whether it was established historically, and then it looked as whether it arose out of questions of liberty, and they found that they were not able to derive a right to abortion out of either of those 2 lines of investigation. So substantive due process was essential to the argument used by the majority opinion, and they didn't suggest they should be overturned, they should be examined, they didn't question it in any way. So Thomas is taking a very eccentric view in suggesting challenging of substantive due process. On the other hand, he does have a point. So in discussions of the Constitution, then many justices have remarked on how slender the basis is for substantive due process. It's only based on those 4 words. And Justice Thomas is an originalist. He is very interested in the original meaning and looking at the words in a very microscopic way. And so looking at it that way, so it's not based on, he's not Republican, it's not based on Republican values or conservative values. For all we know, he might vote Democrat with every single election. Justices are very careful to erect a huge barrier between their personal views and their decisions. As I said, that if the case on interracial marriage came up, then he would have to accuse himself, because it would be very difficult, being in an interracial marriage himself, for him to erect this barrier between his personal views and his judicial decision. So in the same way, they have to erect a barrier between their views, if they're Democrat or Republican. Then an experienced justice, for all their professional life, they have erected this barrier and they look very carefully at the legal decisions. And I can understand that as a mathematician. When I do maths, then my personal views about this, that, or the other thing is not going to change whether or not the theorem can be proved, or how you prove it. And then another thing to be aware about our justices is that lots of people think, well, but he was appointed by Republicans, so therefore he must be Republican. That doesn't follow at all. So he's just a justice, and if he's a professional justice, he is not ruling by his political views. And if he was appointed in a different way, not by a president, then I don't think anyone in the United States would say that he's ruling based on Republican values. We, the justices in the United Kingdom, are not appointed by our prime ministers or political parties, and nobody even thinks that it could be, that they even considers the possibility that they make decisions on political views. It's very rare that the Supreme Court in the United Kingdom does anything that is like this, but that is kind of affects the government in any significant way. But the Supreme Court did make a very significant decision about which led basically to Johnson, to our Prime Minister Johnson having to dissolve Parliament and seek re-election. And nobody suggested for a moment that any of those justices had any political motives for making that decision. It was just them interpreting the law. And it's the same in the United States. I don't believe for a moment that Justice Thomas is, and we know that his wife was at the January 06 riots. But this, again, a good justice will not be affected by such things. She is her own personal being, and what she does is totally irrelevant to his legal decisions. So her views should not impact on his legal decisions in any way whatsoever. It's like, I won't go into too much, but we've got the Speaker of the House in the United Kingdom, and people brought up the sticker that was on his car, and he said, and they said, that doesn't this show that the sticker that supported Brexit? He said, doesn't this show that you're not an impartial speaker? The speaker in the United Kingdom is not like the speaker in the United States. They just they just look at, make sure that everything is being done properly in the House of Commons, and they're not permitted to vote themselves. And so Speaker Bercow, and so someone said, you seem to be partial because you've got this whole sticker about Brexit, and he has this very funny exchange where he says, well, I'm sure that the honourable gentleman, I'm just interrupting you because of a point of fact, because you have made a factual error, which I'm sure you didn't intend to make. And he said, but the sticker is affixed onto the windscreen of the car of my wife, and I'm sure you wouldn't say that my wife he's a chattel or a belonging, and so then he got a big laugh from that. So but it's the same idea with the justices, and his wife is not his chattel or belonging, and what she does on January 6th or whatever is not going to is not something that that he is that is part of his personal choices, and it's not something that is going to impact his legal decisions. The experience justice will, if he was in January 6th wise, that would be a very different situation. But his wife, it doesn't mean that his legal decisions are impacted by her going. So then yes, I explained about I'm not sure if I'll just bring this up very briefly, that for instance in maths we have different ideas about something called the axiom of choice, and most people will never heard of it, but this is an axiom which says if you have infinitely many pairs of boots, then it's very easy to choose all the left boots and all the right boots because they look different. But if you have infinitely many pairs of socks, of course these are mathematical objects in the way it's used in maths, but I'm using a metaphor which is a metaphor that's actually used often by mathematicians to explain the axiom of choice. And if you've got infinitely many pairs of socks, there's nothing to let you choose one sock rather than the other because they look identical. So how can you devise a procedure that will pick you up one from every pair of socks, because you've got nothing about the socks to distinguish them between the two. So you have this axiom which can't be derived from other axioms, which says that if you have infinitely many, and you can't do infinitely many choices, you see, because that would mean doing infinitely many things. So how can you choose at once infinitely many all of one pair of socks when you haven't got a criterion you can use to separate the left from the right socks because they look the same? So some mathematicians say that you should do maths with the axiom of choice, and some mathematicians say you should do infinite maths without the axiom of choice. And this has consequences, because you would think this is quite an innocuous axiom. Why not just assume that you can choose one from each of an infinitely many pair of socks? But it turns out that if you take that axiom, then you can derive from that you can take a solid sphere and divide it into 5 pieces. Now these are very strange pieces. They're made up of, they're not solid, they're made up of lots of little dots that are not connected with each other, but they all fit up together. All those points make the sphere. And if you choose the axiom of choice, then you can divide a sphere into 5 pieces. Take those 5 pieces apart, put them together in a different way, and get 2 solid spheres of the same volume as the one you started with. So your very innocuous axiom about pairs of socks turns into an axiom that is deeply unintuitive and doesn't make sense. How could you take one sphere apart and make 2 spheres of the same volume without any gaps or holes in the 2 spheres, and without changing the size or distorting any of the pieces, and they just fit together neatly to make 2 spheres? But that derives from the infinitely many pairs of socks. So you get some mathematicians say, well, that's just a funny, strange case. We'll just never use the axiom of choice like that. So we want to use the axiom of choice because it's very convenient. And other mathematicians say, well, no, we'll try to do maths without using this axiom, even though it's very awkward to do maths without it. So you have these 2 groups of views in mathematics, and you have some people that do set theory with choice, and some people do set theory without choice, and you can research in one or the other, and you could do a doctorate in set theory with choice, or you could do a doctorate in set theory without choice, or you could do a doctorate in the difference between the 2 ways of doing set theory. So now imagine the presidents, for some reason, it's legally important to be able to choose one each from infinitely many socks. It's obviously not going to happen in reality. I'm just using this as a metaphor, an analogy, to explain how the presidents work. But suppose it was legally very, very important to be able to choose one each of an infinitely many pair of socks for some reason, and you could derive legal consequences from it if you could do that. And then some of the justices believe you can, like you use the assumption that you can do it, and some use that you can't. And now the Republican presidents, for some reason, like to be able to choose one each of infinitely many socks, whereas the Democrats like not to, because they prefer the legal consequences of the justices who think you can't choose one each from infinitely many socks. Then the Republican presidents would all choose the mathematicians or the justices who are willing to work with this assumption that you can choose one each from infinitely many socks, with the Democrats would choose all the justices who don't work from that assumption because they get legal decisions they like. Then, in that situation, you would end up with 5 conservative justices who all are in the point of view of legal point of view that you can choose one each, have the legal view that you can choose one each of infinitely many socks, and then the 3 liberal justices would have the legal point of view that you can't do it. So that would not be due to them having a conspiracy theory about this idea. This would just be because the presidents, and it's not because they're Republican that they have this, that they assume you can choose one each of infinitely many socks. It's just because Republican presidents choose the justices that already have that assumption. So in the same way, it's just very much the same with their views on abortion, although it's much more emotive. But using the idea of one each of infinitely many socks, by taking away the emotions, can then maybe help you to see how this whole process works. So as far as the justices are concerned, these are just their understanding of the legal words, and it's no more emotive in their decision making than the axiom of one each of infinitely many socks. It's just their legal interpretive philosophy. It's not they're not emotionally tied up in it, and they may well vote Democrat. They may well vote pro-choice. It's quite possible that 5 justices, and it's quite possible out of 5 that 1 or 2 or several would be Democrat. There's no way to know. So this I hope helps you to see that Justice Thomas is the minority of 1 out of 8, and then the others, they were pre-selected by the president for the possibility of them overturning Roe. There's no reason to expect them to be any different from any other justice in the United States in their views on overturning anything else, because they're independent. They don't depend on each other. And as they said there, they all agreed that the Dobbs decision does not imply anything for the other decisions. So their views on the other decisions, it's not like they depend on each other. It's not like that if you choose make that decision on abortion, you've got to make that decision on gay marriage. So there's no reason for them to be any different from any other justice on gay marriage. So then, if we go and look, and if we look at their previous, as I say, this just not an argument in the pro-choice, pro-life debate. I'm just helping people who are scared who are pro-choice. But it's not. I'm actually from United Kingdom, which is at least the United States, in countries recently pro-choice. That women can have an abortion up to 24 weeks in certain circumstances. Anyway, the arguments in the majority decision, they were so do I need to go into all that? I think I said the LGBT. I've talked about reliance, I think, already. Did I? Yes, I did. So the Supreme Court, the bit about reliance was about how the Supreme Court justices, they decided that they were not equipped with the authority or expertise to decide if the American people do rely on abortion in the legal sense. So the legal sense of reliance is very different from what you might think of as reliance, because if you think, oh, I rely on being able to get the bus to go in at 10:10, say, but in the legal sense you don't rely on it, because so long as the bus company tells you that they've changed the bus time or timetable, it isn't 10:10, it's 5 p.m., then instead of 10 past 10 in the morning, say, then you will just have to rearrange your make new decisions. Might even have to well, if you have to get a taxi, maybe in that sense you rely on it. But if you have to wait an extra hour or something, so as long as you can change as long as you can change what you do based on the new law, then you don't rely on it in the legal sense. You only rely on it if it's something that you can't adapt to, basically. So the legal sense of so if the women who used to rely on abortion don't can change their behaviour in such a way that they no longer rely on abortion, then and they can do that, then that wouldn't count as reliance in the legal sense. However, Casey added in this extra idea that they depend on abortion in order for their how they think about themselves and about their intimate relations, then that does count as reliance, because if that is true, then there mightn't be any way to adjust, to still have those intimate relations and that the way they think of themselves in society. In that sense, then they would rely on it, because they can't just adjust their behaviour because something is essential to them in the liberty sense. Then they can't check. They lose that as a result of the decision. So if that is the true, then they do rely on it. But the Supreme Court said that they can't make this decision because the way that the status of fetus is so intimately rolled up in it, so the legislative body has to decide this matter, and the voters have to vote for whichever they want to vote for. And so the Supreme Court is not trying to kind of stack it up for the Republicans or the Democrats. And it might well be that the result of them overturning Roe is that Biden then gets a majority in the midterms, and then he legislates for Roe. Well, the Supreme Court would still make the same decision even if they knew that was going to happen. So it's not based on them wanting some particular future thing to happen. It's based on their idea of the legal situation. And it's because they are originalists, not because they're Republican. And they're not involved in some strategy or some plan to try and create some particular future. They are just making the legal decision as best they can. So it's based on the entrenched right for liberty. So that, as I said, the KCI sense of reliance is based on the entrenched right of liberty. So the entrenched right is based on that substantive due process that I was talking about. And the entrenched right of liberty is the substantive due process. From that they draw the right for liberty, and then that liberty then is of this very special kind in the KC decision, which the Supreme Court say that they don't have the authority or expertise to rule on. And so they saw it as an inappropriate exercise of raw judicial power to decide this matter. Whereas on the other hand, it's not based on reasoning about privacy, already said that, and they said that it's based on substantive due process. So the right to abortion is based on substantive due process, but they then, does it fall under the historical, and they all through liberty, and after much discussion, they said, no, neither, but it's, well, they said this, sorry, I should edit that thing, it's really not under historical, they did see it as based on the entrenched right of liberty. I should edit that, I got that title wrong, but they couldn't decide that. They examined liberty and found there's no different from other situations. The court, so as you can see, that title doesn't match the next title. I just made a mistake in the title. They examined liberty, found it's different from other situations where the court has been able to rule on the entrenched right of liberty, because it also involves the status of an unborn fetus. They found it's not for the judiciary to rule on what that means for liberty of the woman, because you've also got the question, is there a question about the liberty of an unborn fetus? is an unborn human being, doesn't have rights of liberty, and should those in some ways be weighed up with the right of the woman, and does this affect the entrenched right for liberty that they found through due process the woman has, but is that in any way affected by the liberty of the fetus? That was a legal question. And that is something that they said they just don't have the expertise or the authority to decide whether the fetus itself has some entrenched right of liberty that should be involved in the whole question. So that's why they did agree that it was based on due process, on entrenched right of liberty, that it's based on reliance, but they couldn't work out what the reliance is. They said they just don't have the authority or the expertise to decide if there is an entrenched right of liberty of the fetus that somehow should be involved in all this. And so does the woman have liberty to destroy a fetus as a potential life, an unborn human being? And they said those are questions for legislators voted in by the public to decide, not justices. And about 26 states are still asking for Roe to be overturned. Now, so ironically, as I've just explained, the majority view of the Supreme Court is that they were being careful not to exercise raw judicial power. So everyone who's scared of this is saying, oh, Roe means that the Supreme Court are getting above themselves. They're exercising judicial power to kind of change the. This is not how the Supreme Court justices themselves think about their decision. They think they're being careful not to exercise raw judicial power. Now, the three liberal justices accuse them of exercising raw judicial power, and they say that they are removing the liberty of pregnant women to make decisions through inappropriate use of judicial power. They're inappropriately using judicial power to remove the liberty of pregnant women to make their own decisions. So liberal justices say these whole questions about, does the fetus have an entrenched right of liberty, however you might think about it in informal terms, but the judicial idea, then they say this is something that individual women have to make up their own minds about, and that it's not something for justices to get involved in. So they have the kind of opposite view of this. They're still limiting the Supreme Court. They're saying the Supreme Court can't decide this, but they're saying leave it to the women to decide. And they're coming to pro-choice, but it's still based on legal interpretation, and some of the three liberal justices may be pro-life, for all we know. They may vote Republican, they may be fundamental Christian. I haven't actually checked any of them, all of them, but it's entirely possible. It's based on the legal decision, their understanding of the law, not based on their political or religious views. So, I explained that about that. In case it depends on the broadest question of whether people's intimate relations and views of themselves in society depend on reliance on abortion and contraception fails, and that's the whole, and that's what they say, so difficult to, so I've explained all this. And so, and the Supreme Court also said justice can't ban travel to get an abortion. So Justice Kavanaugh was a pivotal vote in the decision. He was very clear about this. He said this is an easy decision. This is not a difficult decision, he said. That there's no way that states can ban travel. So if this does get up to the Supreme Court, it's exceedingly unlikely that they would probably get much more than a 5-4 majority against them, because probably some of the other Conservative justices would agree with him, but he felt it important enough to say it explicitly, and liberal justices would surely agree, and Justice Roberts would surely. Well, anyway, so Justice Thomas, he was in the minority of one. I did explain, I think I skipped past it. I got it there somewhere. The Supreme Court was tested in 2020 before Justice Ginsburg died, and before Amy Coney Barrett, sorry, not Barrett, not the poet, Amy Coney Barrett, then she before she became a justice, then the decision was 6-3 pro I'm not reading the text here, I'm just remembering, and it's earlier in the page, I think. It was a 6-3 decision pro the LGBT favourable view on the interpretation of the word sex in a particular bill. Sex they took to mean all LGBT as all counting as sex, as different sexes. So the LGBT, it was particularly about trans. So they took a much broader idea of sex than an LGBT favourable one. They said that this decision was relevant to trans people, and so it was the LGBT favourable one that the legislation with the word sex in it, and was something I can't remember the details of the actual decision now, but it was something to do with unfair dismissal or something. I can't remember what it was, but they said that they were protected by interpreting the word sex in an LGBT favourable way. So that was a 6-3 majority decision, and there's only been one justice since then, so even on that there would still surely be at least a 5-4 decision, but we don't know what Justice Amy Coney Barrett thinks about that, but she might well be on the LGBT side too, because she was only chosen because of her previous decisions on Roe. It might well still be 6-3. There's no way to know, because they haven't had an LGBT type decision yet. Now, overturning Obergefell for the gay marriage would be a much more major thing, and it seems exceedingly unlikely. It may well be more than 6-3 would be against that. It indeed seems quite likely, because Obergefell was based on entrenched rights and substantive due process, and only Justice Thomas is against that, and it seems pretty certain that they'd probably be 8-1 against him on that, if he decided it should be overturned. I think I've left the... It was also in the 3-6 minority, no surprise, in interpretive sex or in LGBT favourable way. Yeah, I talked about that. Substantive due process. I just want to find the bit about the section about due process. Where is it? So, I mean, there are various things. The Supreme Court is... Oh yes, I wanted to talk about... We're never going to have death camps for gay people. That is just very much against your entrenched right of liberty. There's absolutely no way. If you go back to Obergefell's case, Lawrence versus... No, not Obergefell. This was the Lawrence versus Texas, the case that established the right to private sex between adults, including gay sex. Then Lawrence just got a $100 fine, increased on request by the defence attorneys to $125 so they could appeal. So there were prison sentences. I'm not sure way back. I'm not sure if he was still around at that time, but certainly in this particular region, then it was a fine of $100, and there was no right to enter houses to see if there was gay sex. It was just that the police were there for another reason, and they noticed the gay sex going on, so they had to decide what to charge them with, and they decided to make that charge, and that went all the way up to the Supreme Court, and it was proven that it was okay. So, and then comparison with other countries, then if you look at other countries, then Brazil, Mexico, others, I think Brazil still has abortion illegal. but Mexico, it's legal in Mexico City. It's legal in where's Mexico? I can't remember the situation. Maybe abortion is. I've got a whole section about that somewhere on the page. But the what's this about? Oh yes, and they didn't decide against. So I'm just explaining that. Yes, Brazil still criminalises abortion, but it can lead to a prison sentence of up to several years for the woman. So Brazil still has abortion criminalised. Most of the other Latin American states, like Mexico, and I've got a long list of them down there, and they used to have illegal abortion, but it's now legal. Now, but only some of them only recently, only last year. But on gay marriage, they have all had legal gay marriage for several years now. So this is a clear example of a Catholic country, which is presumably very similar. And it was often by the Supreme Court that made that decision. In at least a couple of them was their Supreme Court that made the decision that gay marriage was legal, and also made a decision about abortion. And so this is an example to show that Catholic justices. So the relevance here is that the 5 conservative justices are all Catholic. But that doesn't mean that they. So if you look at Catholic justices from the Latin American countries, they have not made decisions saying they've made decisions favourable of gay marriage. So that shows there's no necessary connection between decisions about abortion and decisions about gay marriage for justices, even in countries where just about everyone is Catholic. And then an important point about it's also important to realise that Sotomayor is a Catholic and voted to keep Roe. So they weren't voting according to their religion. Presumably she would be pro-life in her own personal decisions, but there are actually many Catholics actually the majority of Catholics in the United States are pro-choice, in the sense that they think laws should permit abortion. It's this column, I can't, is it 56 or something? I'm not sure. Anyway, if you can read, I would need to get my glasses on. Anyway, that, I think it says 56. Anyway, those are the Catholics. And so the idea that just because they're Catholic that they must be against choice is not likely. Indeed, if those were just randomly chosen Catholics, then you would expect probably either 2 or 3 of the conservative justices in their own personal life, not in the legal decisions, to be pro-choice. It's quite likely. It might well be, because remember, these things, they're very careful to keep these things separately from each other. So it's entirely possible that some of them are pro-choice, although they overturned Roe. Yes, we'd expect 3 out of 6 to be pro-choice, and there's only a chance of only 1 in 6 being pro-choice would be only 0.335% if it was based on those percentages, and if they were just chosen at random from Catholics. So this situation that only 1 out of 6 was voting against Roe is exceedingly unusual, but it's not based. Remember, it's based on legal interpretive philosophy, and it's based on presidents choosing justices, and who had that interpretive philosophy. It's entirely possible that 3 out of 6 are actually pro-choice in their personal life. And even if only 1 in 1,000 of the Catholics in the United States had this particular legal interpretive philosophy, then the presidents would have been able to filter through them all, and they would have probably found ones that were good, were sufficiently respected to become a Supreme Court justice, just because there's so many really excellent justices in the United States. So it's entirely possible, given that they're only chosen every now and again, to every time find a really excellent justice who just happens to have the particular legal opinion on one particular matter that the president wants. And that's basically what happened here. It's not based on the justices, it's just based on the presidents. Yeah, I said 1 in 1,000. I think I've explained most of this. And then, I just want to say again, people also have a lot of people who have PM'd me about this, or in the group they've talked about it, or in comments in Quora, then they've worried that the Supreme Courts, they don't think that these Supreme Courts are telling the truth. They think they're lying. No, there's no reason to suppose they're lying. And this is because, now, myself, I don't have a legal background, as I've explained before, so I originally thought that how could this possibly be compatible with what they said? Because I listened to Amy Coney Barrett's confirmation hearing myself, and she, at least the section about reliance, and then it was very hard to understand how she made this decision. But then I looked again at what she said, and I think I even just had to think a little bit longer. It didn't take long, and then I checked and confirmed, and then I also checked Justice Kavanaugh. And I mean, I actually remembered, but I think for a moment or two I didn't remember. But I actually remembered that yes, I didn't have to look it up. She said that she was very careful to say that she couldn't prejudge what she would decide as a justice about Roe. And all the justices said that, because that would be extremely unprofessional. If you want to bring your court brought up before a justice, you don't want to hear that this justice has already decided against you before they even saw your legal arguments. If you take it from the point of view of the plaintiffs, then you can understand why they were not permitted. They just know it's not something you can expect of a justice for them to say what they're going to decide about a case that they haven't yet seen the legal arguments for. And because the justice is always ruling about particular cases with particular legal arguments, they don't rule in abstract. It's always based on someone has come to them and said, this particular thing happened, this is my argument, this is the opposing person's argument, what do you decide? And it would be extremely unprofessional for them to say in the confirmation hearing, if Roe comes up, I'm always going to decide that Roe should not be overturned. That would be, they should be rejected if they said that, because that means then they're unprofessional. So Amy Coney Barrett didn't say that, nor did Justice Kavanaugh. And what they did say is that that reliance was very important for Roe versus Wade, and they had to consider it very, very carefully. Well, they actually did consider reliance very, very carefully for Roe versus Wade. They spent pages of legal reasoning about reliance, as I've explained, and then I explained their conclusions. And it's the same for various others of Kavanaugh's remarks. So, no, he didn't lie. None of the justices lied. They were professional justices. There was no way they could have pre-decided, and they were just justices who were selected because the president wanted. It was not really an expectation, but a hope that they might decide like this, because they couldn't prove that they would decide like this. And in the end, they did. So that's that. So yes, like all this might seem like quibbles, but Justice Kavanaugh was just saying legal principles he would use, and there was no way you could know in advance how he would decide on Roe. It would be deeply unprofessional to know already. So please, 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 don't direct your frustration or your anger against these justices. And they are not being unprofessional. You can, it's okay to say, well, okay, it's all because of shenanigans by the Republican Party or by Trump. There may be some basis for that, and it's particularly not recognise the way the Republican Party didn't let Obama choose his justice, and yet they were forcing fewer justice, their own justice, at the very last minute. So this sort of reasoning, and that is politics, that is legislation, but that's very different from the way the justice think. So of course the two sides to that, but that is politics. So that legislators do that sort of thing, but justices don't do that sort of thing. So try to keep them separate, and then that helps to have much better clarity. And because the problem is that people start off by saying, oh, the justices must be lying, the justices must be really Republicans, the justices must have an agenda to turn the United States into a Christian autocracy based on fundamental Christian values. This is not true. There's no basis for that at all. It's just ordinary justices, but you can look at the Republicans that chose these justices and wonder if they had such an agenda. And I don't think it went as far as that for them either. But it's reasonable to try and put that over to the Republican presidents, but it's not. That is not. Please be careful to distinguish the justices from the presidents that selected them. And this will help you to be much less scared about the justices' decisions. They're not suddenly going to go rogue. They're not going rogue. They haven't gone rogue. They're just being normal justices. And then there's quite interesting, if you look at the empirical studies of judicial decisions, they're based entirely on behaviour and don't look. So this is a whole field that you have in the United States. You don't have it in the United Kingdom. Nobody even considers that as a possibility. But in the United States, then some of the academics there look at the decisions of justices and they derive an inferred value of whether it's a liberal or conservative. And this decision of whether they are making liberal decisions or conservative decisions predicts well many of the decisions, but not all. So the liberal justices do make decisions that, looked at externally, look like they are liberal decisions, and conservative justices make decisions that look conservative, look like conservative, that they're based on liberal values or based on conservative values, rather similar to conservative values of Republicans or the liberal values of liberal Democrats and conservative Republicans. So the decisions do relate to decisions that might be made if it was based on a liberal or conservative ideology. However, that doesn't mean that internally they have an ideology of liberalism or conservatism. There are many things that don't fit those decisions. And the academics that have this view, they basically, it's not scientific, it's irrefutable. Because if something doesn't fit the inferred liberal or conservative, then they discard it. They say that was an exception. And they don't have a criterion that could be used to disprove their theory. There's no way that their theory could be disproved. Because if you find a conservative justice that makes a liberal decision, they will just say, well, that's one of the exceptions, and same the other way around. So it's not a scientific theory. It's a kind of academic politics or something. I'm not sure quite what you call it, but it's not science, in my personal opinion. And the justices themselves, they don't think about them. They don't think. If you actually ask justice what they're doing, they say they are not using any conservative ideology. They are using the original meaning of the text. An example of Justice Scalia, because you can ask Justice Scalia. They could ask Justice Scalia what his judicial philosophy was, and he would be perfectly prepared to explain at great length what his interpretive legal philosophy was. And this was a much better predictor it's a much better way of predicting what they would decide. It's not based on a conservative ideology. It's a much better way of understanding what they said. You can't actually know in advance exactly what they will decide, because there are many different ways of applying an originalist what's the right word? The original meaning. The original meaning of the text it's not as simple as that you just say, oh well, you go back to this text, well it's obvious what they meant. It's not as simple as that. It's extremely very involved investigation trying to work out what the original meaning was, or indeed what is meant by the word original in the original meaning of the text. So there's lots of different ideas about what exactly meant by the word original and how you measure it. I mean, is it, for instance, what the famous were thinking, or was it the general way that the word was used by people at the time, or do you need to go to the notes that the famous actually may have taken notes and of some of their discussions that led up to the actual final decision, or is it about how people at the time of the decision would have understood the text after the bill was passed? And I know those are two or three of the ideas. There's several others, I forget all of them. So there are lots of ways in which you can look at the original meaning, and someone like Justice Scalia used not just one but many different meanings to the word original and played them against each other and tried to work out which was the important one for a particular case. So they'd favour, and a particular originalist justice will have a weighting or a favouring towards one or other of those different ideas of originalism. But you might well take up another one, and depending on the particular case and how it relates to it. So, as I said, justice have struggled for centuries to erect and defend this barrier between justice and personal ideologies. And some justices have been very scathing in their views of these studies by the academics who claim to detect an ideology of conservatism or liberalism in their decisions. So I think it's also important to realise that from the justice's point of view, and it's not just the justices, this was Judge Harry Edwards of the DC Circuit, so it's not just the Supreme Court justices, all the justices have agreed that it's not how the justices themselves think about their own decisions. They keep them very separate from any personal ideologies, and they work very hard and they train other justices. If a justice is teaching his students, they train their students like that too. So and I just find it beyond credible that with so much training and so much care that they could really actually be secretly conservative or liberal and making decisions based on conservative or liberal ideologies. I don't believe that for a moment. So no, they're making it based on their interpretive legal philosophies. And so, as I say, for me, trained as a mathematician, it's very much like the way we do mathematical proofs. And if I go through a mathematical proof, I don't say, well, I would really like that to follow from that, so let's just say that follows from that, and hope that nobody notices that it actually doesn't. I mean, you don't do maths like that. You might do it by mistake, but you don't do it deliberately. it's the same for these lawyers. They're being very careful. They're meticulous. They're drawing things from one set of words to another, and they're very focused on the words and the understanding of the originalist. Well, liberalists have other interpretive philosophies, but it's still nothing to do with liberal values in the Democrat sense. The liberals are much more to do with how the interpretation has changed towards the future, to what is the current understanding rather than the past understanding. So that leads them to be much more likely to have things that Democrats like as their interpretations. That's a very rough. There are about 5 or 6 more liberal philosophies I looked up and I read up about it, and I wrote about it some time back. I don't remember the details at all now. I'd have to go and look it up to look up my previous debunk to talk about that properly and intelligently. That's just a very rough idea. And so it's very different from the way that legislators reason and argue in Congress. So in that case, legislators, it is based on personal views as well as the views of the people they represent in their constituency. So a good legislator is not legislating based on his personal views, and especially a president. So President Joe Biden, sometimes he'll completely hide what his own personal view is. He is there to represent his manifesto for the election, which he put in front of the American people. And Kamala Harris is the same too. So when President Biden was Vice President Biden with Obama, then he was there to present Obama's manifesto. So he was presenting different ideas back then. That was, again, something people get confused about legislators. They seem to change their ideas, but it's really that he is now on a different manifesto. And this manifesto represents the view of the American people because they voted him in, according to the democratic theory of a parliamentary or this kind of indirect democracy that the United States is, instead of the direct democracy where people vote on every decision. Then for an indirect democracy, then the people vote in a government, and the government puts forward a manifesto for the election, and then the people, when they vote for that government, then they are supporting that manifesto, which gives them the basis, the democratic basis, to be able to then go ahead and do the things that they set out in their manifesto. So, and the manifesto is not Biden's personal views, it's the result of a lot of discussion between him and his advisors, with other Democrats, and the different candidates had different ideas for the candidates for the Democratic presidential candidate. I can't remember the word. The ones who wanted to be the candidate, and they had different ideas. There would be a different manifesto if it was Biden, and so it was. If it was, say, Bernie Sanders, it would be a different manifesto. But it was Biden was the one who went through that part of the process. He then presented his manifesto to the general public, the American people. They voted him in instead of Trump. So now he has the can't remember the word, the mandate. He has the mandate to put his manifesto into law. And then if he goes to the midterms, if he comes out the midterms with a majority in the House and a 2-seat majority in the Senate, he will then have a mandate for whatever his manifesto is as he goes into the midterms. So he's already said, for instance, that he is open to drop the filibuster for abortion and general matters of privacy and for voting rights. So if the Democrats get a 2-seat majority in the House, in the Senate, and a majority in the House, and according to the theory, the democratic theory, democracy theory, not the Democratic Party, democracy theory, then he has a mandate to then go ahead and do what he said he was going to do, which was do a carve out of the filibuster. So he will have a mandate to do that. That's how legislature works. So the legislators, they present their own personal views, but to some extent, but also they're supposed to represent their constituency. The president is supposed to represent, to some extent, his personal views because he's got the confidence of American people to make personal decisions, but also his manifesto, so that's very strong for president. And then for representative, then he very likely made some promises during his election campaign, so then he's got a mandate to try and fulfill those promises as best he can, to push them forward in the Congress, to vote for them, to if it's something, do things that he can to help move those things forward. So and then again there's a certain level of personal things as well. So there is that thing as well for the legislature, but the legislature is representing the people. The justices aren't representing the people. The justices are interpreting the Constitution and interpreting the laws that were passed by legislation based on the Constitution. So the only thing that the justices have that support them is the Constitution and the laws. And the things like the response of the American people to those laws, like whether they rely on those laws, and whether they've raised objections to them. And that's how the justices look at it. They're not there to represent the views of the American people. They're not there to try and make new laws of their own. That's for the legislature. So that's the theory of the three. And then the president, so the president is representing American people, but he does not make laws. The president of the United States instantiates the laws. He brings them into action, although he's got a lot of freedom of choice on foreign policy. But especially on internal policy, then it's to do with bringing into, because the laws are basically about most of the laws are to do with internal things. And he's constrained by the laws and he executes the laws. But then some of them are about external things too, but he has quite a lot of liberty on foreign policy and like discussions with leaders and so on, trade agreements and things. But again, it's all very complicated, and I'm not very expert on this at all. But that's just to give you a rough flavour of the idea as to how the three branches of US government and US Constitution and the Constitution is above it all. It's all based on the Constitution, and then you can amend the Constitution. That's very difficult, and there's a process as to how to do that. So, I think this is the end. Let's see if there's anything else. Yeah, if you had a commission of lawyers and justices to select the Supreme Court, like in the United Kingdom, I think it would be very strange. It would be very, you'd be absolutely clear that how independent the justices are. They're not legislators, they're not representing their own views, they're not representing the views of any group of Americans. That's the main point. Justices are not presenting the views of any group of Americans. They are interpreting, their job is just to interpret the law and according to the Constitution. But they do take account of the behaviour of the American people in interpreting the laws and how they respond to the laws and the cases they raise and things like that. And as I can tell, as far as I can tell, interracial marriage isn't prohibited anywhere in the world. US was one of the few places with laws against interracial marriage by 1979, which was when it was eventually prohibited in the United States. And in 1979, there was no interracial marriage between Chinese nationals and non-Chinese. In 1979, I believe. At least the source that I read said so. But there was no law against it. It was just custom. And it's the same with some other groups of people. Some Muslim women don't marry non-Muslim men in some countries by custom, but it's not in their legislature, in their law. So there isn't any country, as far as I can find out, where interracial marriage is prohibited by law. In some places it doesn't happen by custom. In China, of course, you now have lots of interracial marriage, but back in 1979 you didn't. So and as I said, he sees it in interracial marriage. And gay marriage, oh yes, I talked about that. Just double, I've got the numbers here that I wanted. Right, here we are. So Argentina legislated for gay marriage in 2010, and legislation decriminalised abortion up until 2021. So, judicial decision for gay marriage in 2013, and abortion is still a criminal offence for a woman. Colombia, judicial decision for gay marriage by Supreme Court 6-3 vote, and judicial decision to decriminalise abortion not until February 2022. In Mexico, judicial decision for gay marriage in the Supreme Court. Gay marriage in the Mexico City must be accepted throughout the countryside, and some other regions also have gay marriage. And it took until 2021 for a judicial decision to decriminalise abortion. Up until then, a woman could get a prison sentence of up to several years in Mexico for getting an abortion. So, and another one, Uruguay, gay marriage 2013, abortion legal 2012. So that is a very kind of liberal Catholic country. So that's a very clear example to show that Catholic justices, for whatever reason, tend to decide in favour of gay marriage and tend to decide against that abortion is a criminal offence in Catholic countries. But in the United States, because of the US, based on the US Constitution, then they did not make a decision in that direction, and they didn't say abortion is a criminal offence. They said that this is something that legislators have to decide. If the US want to be counted, and this is out of date now because Biden said that he will do a carve-out of the filibuster for abortion. Yes, so and it's not likely, because they would have to add, it's not likely that Republicans ever make an abortion illegal, because that would need to be added to the manifesto and lose them votes. But if the Democrats carve out the filibuster, it could open the door for them to modify the law, e.g. a lower limit into a codified row, or a codified 15-week ban. But again, they would need to do that in the manifesto, or else they don't really have the mandate to do that, because that's a very major decision to make for the entire country. And if they don't, according to the theory of democracy in the elected parliamentary system of democracy, then they just do not have the mandate for a 15-week ban unless they go to an election with that as a proposal. And they're not likely to do that because that would lose them votes, because 61% of the American people are pro-choice. So this makes it very unlikely that Republicans will make abortion illegal or restricted at a country level, whereas it is quite likely that at some point, so long as a majority continue to be pro-choice, then at some point in the future, then that's likely to turn into legislation in the Congress at some point, if not necessarily at the midterms. And that's how it works. I'm in the United Kingdom, where we don't have a filibuster. Almost no countries have a filibuster, and it doesn't flip-flop from one government to the next, because you would have to go in a manifesto, and if your manifesto is against the general, the majority view of the public, then you'll lose your votes. So it's very bad for someone with some minority view to try to push it through in a manifesto, because it loses them votes. Of course, in some detail, but not some major thing like this. Right, so that is that. That's a somewhat longer video, but I think for the thanks if you've listened to the end. I'm not quite sure how long this video is, but it's one of my longer videos. But hopefully there are lots of interesting things to go into there, and I know that some of the people that I talk to will value this level of detail, and so I was wondering halfway through as I talked, should I stop this? And you just cut it off and just say this is getting a bit long. But I think some of you will value it going into this level of detail. So thanks for your patience. I hope it was interesting. Any questions, do say. And if you have any particular ideas of particular videos you want me to do, then do say. So I'll now upload this.